we will commence the webinar. Carol, could you start recording, please?
Yes, I'm done. Okay.
Okay, good morning and welcome to today's Employee Ownership Explained webinar, the role of the legal advisor in the EOT transaction. And many thanks for joining us. For those who don't know me, my name is Angela and I look after the marketing and communication for CDS. Just before we get started, I'm going to take a few minutes to talk you through details of how today's session will work. I will be your host. Carol Leslie, one of our specialist advisors, will be managing the technology and facilitating and participating in the Q&A. And Bruce Barker from Anderson Strathern will be our speaker. As an attendee, you should be muted with no live video. You will all have caught sight of the agenda. However, as a reminder, today's webinar will begin with a short overview from me and a poll. Bruce will deliver his presentation and that will be followed by a Q&A session. Please feel free to ask questions throughout the session using the Q&A functionality. These will be addressed during the Q&A session. You will also have the opportunity to raise your hand and ask a live question during the Q&A. After the Q&A, there will be a final poll and the session will close. When we close the webinar, a short evaluation should appear. We would be grateful if you could complete this. If this isn't possible, a summary of the session and a recording will be sent to you along with the evaluation. So let's move on to my overview. Who is CDS and why employee ownership? In case you're not aware, Cooperative Development Scotland is a specialist unit within Scottish Enterprise. Our role is to raise awareness of and increase the number of businesses considering employee ownership. We offer our clients an ownership succession review and an employee ownership feasibility study. So why employee ownership? There has been a real surge in interest in employee ownership since the 2014 Finance Act introduced a new model for employee ownership, the Employee Ownership Trust, otherwise known as the EOT. However, more recently, we're seeing three main reasons for the increased interest in EOTs. Owners looking to retire, a decrease in entrepreneurs relief, and a potential change to capital gains tax. So what does the employee ownership sector look like? According to the White Rose Centre for Employee Ownership Survey 2020, which took place in June, there are around 470 employee-owned businesses in the UK, with Scotland second only to London in the growth of employee-owned businesses. According to the CDS database, there are over 120 employee-owned businesses operating in Scotland with a combined turnover of around 900 million and around 7,500 employee owners. With regards to transactions, there have been at least 9 sales to EOT this year that we're aware of. The Scottish Government has an aspiration for the sector to have 500 employee-owned businesses by 2030 and has set up a public-private partnership industry leadership group called Scotland for EO, which CDS is part of. And finally, here are some examples of employee-owned businesses. Before I hand over to Bruce to deliver his presentation, we will conduct a short poll of 3 questions. We would be grateful if you could respond to these. Apologies to those who have attended our previous webinar. You will already have seen these questions, but maybe your responses will have changed. Here we go. Number 1.
Yeah, that's just about everybody voted.
Fantastic. Looks like quite a kind of even spread mix of accountants, lawyers, business advisors, and again, some business owners here. Welcome, everybody. Okay, for those who don't know Bruce, he is chair of Anderson Strathearn. He is also a partner in the corporate and commercial team and leads the energy sector group, as well as being a member of the Brexit group. Highly experienced and regarded by his clients and peers in the corporate and energy fields, Bruce is also recognised in the independent legal directories, where he is noted as a lawyer who consistently goes beyond client expectations. He's worked on a number of high-profile EOT deals, including New Hopetoun Gardens, Mediascape, and the Priory Hotel. Over to you, Bruce.
Thanks, Angela. I'm going to share my presentation if I can. Bear with me. Okay. Well, good morning, everyone. It's great to join the webinar session this morning. I'm going to be speaking about the role of the legal advisor in the EOT transaction. As Angela explained, I'm a partner at Anderson Strathearn. I sit in the corporate team. I suppose the first question you're going to be asking is, why are Anderson Strathearn presenting today? Well, we've been pretty heavily involved in advising both on EOT transitions and EOT owned companies. And in this slide, I've set out a selection of some of the deals and the clients for whom we act. Now, it's perhaps worth pointing out that you'll see that it's across a range of sectors. There's IT, there's demolition, construction, hotels, garden centres, and that perhaps highlights that EOTs are applicable not only to a handful of different business types, but a much wider range than perhaps people initially anticipate. We've also got 3 transactions live just now, going through the process. Things did slow down on the COVID-19 lockdown, but we're back to experiencing a reasonable flow of transactions and inquiries. So today is an opportunity for me to share some of the learnings we've gained through advising on EOT transactions. And I should caveat things by saying I'm going to be providing observations that we've gleaned rather than legal advice. So what I thought I'd cover off is a run through of these topics. We'll have a quick look at what I mean by employee ownership. I'll look at the EOT statutory requirements. I'll then spend a bit of time looking at the EOT structure or governance model, and then pick up on the role of the legal advisor and the key aspects of the transaction. And finally, I'll look at why clients should be considering employee ownership. So there's a fair amount of ground I'm going to cover off. I'm going to try and keep the pace up. I'm conscious of time. So what do I mean by employee ownership? Well, it's where all employees own a significant stake in the business. And by significant, the sort of most recent thinking around that is that it's 25% or more of the shares. And it's all the workforce owning a stake in the business, not just participation by a few senior executives. And as it's already been pointed out by Angela, we have support at the Scottish Government and UK Government level actively promoting employee ownership. Now, there are a number of different forms that the employee ownership model takes, and there's the 3 main ones that are set out in this slide: direct or indirect or hybrid ownership. And not all of them involve employee ownership trusts. So look briefly at them all. Direct ownership, well, that's, as you would expect, that's where each employee becomes a shareholder, personally holding a number of shares. Now, they normally receive those shares through 3 ways: either buy them, or they're gifted, or they acquire them through share options. And under this direct ownership model, every employee may receive a share of the profits through dividends. They may have voting rights, and they have the possibility of selling at a later date and hopefully attracting capital value appreciation. Most companies that go down this route have measures in place which mean that the employees have to sell their shares when they leave the company. And on this slide, I've given an example of a company that uses the direct ownership model. It's a Sheffield-based precision engineering company. I think it was on Angela's first slide. It was established back in 1988. It has a policy that all employees buy £1,000 worth of shares with the aid of a company loan to help. And I understand that shares that were taken back in 1994 for the cost of £1 are now worth more than £20. Second model, indirect ownership. This is where the shares are held indirectly on behalf of and for the benefit of the employees. And most of the longest established employee-owned businesses in the UK use the indirect form of employee ownership in at least part of their ownership structure. The most common mechanism is through a trust model, and I suppose the poster boy, the poster child of the employee ownership organisation will be the John Lewis group. We have a trust model, I think, as part of their indirect ownership. Since 2014, most trusts are established as employee ownership trusts. Now, I'm sure you'll know this already, but a trust is a legal arrangement under which assets are held by one group of people, the trustees, for the benefit of others, the beneficiaries. And in the EOT model, the beneficiaries are the employees. So under this indirect ownership model, the employees individually don't own the shares. They benefit directly or indirectly as beneficiaries of the trust. And a common reason that's put forward for the use of the trust ownership model is that it will benefit employees over the long term through the trust influencing the company's direction rather than individual interests perhaps focused on more short-term drivers. And lastly, we've got the hybrid ownership, which is, as you would expect, that's a combination of the direct and indirect model. So in this model, the trust will hold a majority of the shares, and that ensures the stability of ownership in the company, but there may be other interests in the company, perhaps through share incentive plans, there may be founders keeping a stake, there may be minority shareholders involved. And again, here's an example on this slide of a company that has a hybrid model. Accord, I think they're an Aberdeen-based company. It's got a trust which holds a controlling interest, and it's got a HMRC-approved share incentive plan which accommodates direct employee stakeholders. Okay, so we've set out the various models. Our focus today is on the indirect ownership model, and it's particularly through the use of employee ownership trusts. Now, EOTs are not to be confused with employee benefit trusts, although I think they can best be categorised as a category of EBT. And we can track the evolution of the EOT to a government commissioned review. Back in 2012, the government commissioned a lawyer, Graham Nuttall, I think London-based lawyer, to review employee ownership. And among other suggestions, the Nuttall review recommended a capital gains tax relief for owners of businesses who sell their shares to their employees. And those recommendations were taken up in 2014, and tax reliefs relating to companies owned by an EOT were introduced. So legislation underpinning the EOTs was introduced back in 2014, which means it's still a relatively new concept, but one that's increasingly popular. Nuttall recommended tax reliefs be introduced, and that's what happened. The accountants and tax advisors will be able to provide more detail than me, but two important new tax exemptions were introduced to encourage employee ownership. The first was CGT from 6 April 2014, disposal of shares in a trading company or a holding company of a trading group, which provides an employee ownership trust with a controlling interest, are exempt from CGT on gains. So instead of a sale of shares for owner managers or founders at an effective rate under the entrepreneur's relief, which was 10% and is now obviously subject to change, there's an unlimited exemption from CGT. And there's no doubt that that alone has promoted increased use of the EOT model. The second change was in relation to income tax. there's an exemption from income tax of $3,600 per employee per tax year for certain bonus payments which are made to all employees of a company, where the EOT has a controlling interest. Now, the detail of these exemptions or reliefs can be found in the legislation, but there are 4 key conditions which need to be met. The first is the all employee benefit requirement, and that means that property owned by the EOT must be applied for the benefit of all eligible employees. And eligible employees means all employees of the company and officers, excluding those who hold 5% or more of the shares or persons who are connected to them. The second condition is the equality requirement. The property belonging to the trust must be applied or distributed to eligible employees on the same terms. And same terms doesn't mean that all employees have got to get equal amounts. It's possible to vary the amounts based on 3 factors: remuneration, length of service, and hours worked. Third requirement, controlling interest. The EOT must hold more than 50% of the share capital and the voting rights, and it needs to be entitled to more than 50% of the profits and assets on a winding up. And the last condition is the trading requirement. It must either be a trading company or the principal company of a trading group. So the deal needs to be structured to ensure that these 4 conditions are met before the release will be available. And having looked at those requirements, which came out of the Nuttall review, let's move to a quick look at the governance structure, which is typically put in place for the EOT model. Now, having said I was going to look at the EOT governance structure, I'm going to start by looking at the more traditional structure of a limited company. And I think it's worth reminding ourselves as to how that operates before we look at the EOT model. So back to basics here, you'll see the structure diagram that's on the slide. The shareholders own the company, and they've got the power to appoint and remove directors and pass shareholder resolutions. The directors are responsible for the day-to-day management, and they're subject to the Companies Act and other statutory measures. And the employees are employed by the company, and they usually don't have a management or role in the governance. So if we look at the EOT governance structure, there's obviously, you can see straight away, a more sophisticated scheme of governance and management. We still have the trading company, which is in the middle of the diagram, and it is either owned 100% by the trust, or there's a controlling interest with other shareholders. The trust deed will have been set up to create the EOT, and it's the trustees on behalf of that trust who will be the controlling shareholder. In the model on this screen, we've got a corporate trustee. So it's a company limited by guarantee, which is wholly owned by the trading company, which is the trustee for the purpose of the EOT. And you can see the employees at the bottom right of the slide. I mean, they have influence on who the trustees will be in the EOT, and they may also have influence in terms of appointing employee directors to the trading company. So I'm just going to flip back and show you, this is the traditional model, and this is the EOT governance model. Now, obviously, the EOT model is more complex, but I could have introduced even more complexity in this diagram. There's often an employee council involved in EOT transactions, and that's not a requirement, but it's a means for channeling the views of employees. So it can be used to decide the appointment and removal of trustees, or perhaps if there's material decisions that the trust needs to take, then they can consult with the employee council beforehand. Employee councils, I think, are mainly used where there's a large number of employees. Less common in Scotland in our experience, where it's typically smaller SMEs which are participating in the EOT structure. I think it's more common in England, where there's perhaps more of the larger private companies with large number of employees that went down the EOT model. So under the EOT governance structure, we need to have clarity and understanding of the roles of the participants. In this slide, I've compared it to a jigsaw with various pieces interlinking. The first question that we're often asked is, what role will the trustees or the employees play in managing the day-to-day business of the EOT, or sorry, the EOT-owned company? And the short answer to that question is none. That remains the responsibility of the directors of the trading company. The trustees own the company. They're the shareholders who have ultimate control, but the trustees are not dealing with the management of the company's day-to-day affairs. And the same goes for the employees. They're not involved in managing the company. They do have a role in appointing the trustee, and they may also have a role in appointing an employee director, an employee representative to the board of the trustee company or the trading company. That's a point where there is a bit of debate and divergence in views as to whether there should be an employee representative on the board of the trading company. Conceptually, I think that's a good thing, positive thing. It gives the employees a direct voice at board level. It shows the employees that the move to employee ownership is perhaps real. But I know that view isn't shared by everyone. I think, Carol, you tend to a different view here. And given the number of EOT companies which you're involved with, perhaps this is worth exploring a bit further in the Q&A session. The directors are the individuals who remain responsible for managing the day-to-day affairs of the company. And those directors will typically comprise members of senior management. There may be employee elected representatives. The founder may still have a seat at the table, and there may be some non-execs involved. But the key takeaway, I suppose, from the last two slides is that the EOT model will have a greater role for the employees in the governance of the company. And that's a move away from the traditional limited company structure that we started off looking at. So I'm going to now move to the preparation, how to prepare for the EOT transition. So we've set the scene around what is employee ownership and employee ownership trusts. What's the preparatory steps that commonly need to be taken to deal with a transition? Now, I put a number up on this slide. All the transactions which we've been involved in have been primarily driven by the owner or the founder of the business. And the deal's not going to happen unless the founder is on board. And in reality, the founder has got to be one of, if not the key instigator for the transaction. In our experience, it's usually as a result of the founder exploring their exit or succession options that the reference to EOT model is first raised. And there's now a very good support network through Scottish Enterprise, through the Cooperative Development Scotland, providing assistance to both founders in relation to advice and contribution to professional costs. And no doubt Angela and Carol can share more information on that later on. Next reference point I put on the slide is the professional team. It won't come as a surprise that there will be more professional advisors than just lawyers. There's usually two other professional advisors, or specialist advisors, accountants and tax advisors. So that may be the company's existing accountants, or it may be a specialist firm, and typically they're involved with the valuation, the tax clearance, and the financial projections. There's also the overarching advisor, and that's an advisor such as Carol and her firm Ownership Associates. And these advisors deal with managing the transaction, providing support for the founders, and probably most importantly, dealing with the planning and sensitivities of the employee engagement exercise. Who's the client in the transaction? Well, in our deals, our initial engagement has been with the target company. It's not been the founder or the employees or the EOT. But you've got to recognise that as a transaction develops, there will be different interests involved, and other legal advisors may be necessary, as you can't advise everybody. So both the founders and the trustees are recommended to take their own independent legal advice as the transaction moves forward. And obviously it's up to them whether they do so, but there needs to be no doubt or lack of clarity on where the client-solicitor relationship lies. Due diligence, well, there's very little due diligence carried out in these transactions. It's likely that the founder will continue to be involved in the company post the transition, and there will be an element of deferred consideration. So there's not such a pressing need for due diligence when compared to a normal arm's length transition. There may be some basic warranties in the SPA, but typically the transaction is carried out in a collaborative manner, with all the interests aligned in ensuring that the EOT model achieves future success. And actually, that's one of the reasons why these EOT transitions are so enjoyable from a professional advisor perspective. They have a totally different rhythm or balance when you compare them to the more normal M&A transactions we advise on. I flagged third-party consents. We've already established that moving to the EOT model will require a change of control. So it may well be that the due diligence involved will include reviewing change of control provisions in contracts. And that could be triggered in banking agreements, property leases, finance contracts. We've seen all of these being triggered in the deals, across the deals that we've advised on. And it may have a need for prior approvals or consents from these contractual counterparties. There may be some pre-EOT structuring required. We've seen this where non-core assets of the company are taken out in advance of the transition. So for example, where there's a residential property owned in the company which the founder wants to acquire. That's going to give rise to specific asset valuation, considering conflicts of interest, and perhaps an increased scope to the professional work. Steps paper or a timeline paper. Similar to other transactions, we find it very helpful to prepare a timeline or a steps paper at an early stage for the transaction. The rule of thumb that we use for clients for the length of time of the transition is that it'll take approximately 3 months. And obviously, there's a lot that can get in the way here, particularly if third parties are involved. And talking about third parties, in all the deals we've advised on, HMRC have been approached to provide tax clearance, and that's done through the accounting and tax advisors. I think they have a 30-day turnaround time, and to be fair to HMRC, I think all the deals that we've been involved in, we haven't encountered particular problems in terms of getting a response back from HMRC. And I should add that it's our preference that ideally all the documents should be in final form and submitted along with a clearance application if possible. So that's the preparatory steps. I'm now going to have a quick look at what are the key decisions that will need to be addressed in the transition to EOT. I flagged the main ones that we've seen. Share price, well, that's pretty fundamental. There needs to be an agreed share price. It's going to have to be agreed between the founder, the trustees, and probably the trading company too. This needs a proper valuation exercise. Needs to be provided in writing. Usually it's the company accountant who carries this out, but it could be another independent valuer. I think the share valuation typically goes to revenue as part of the tax clearance application, so it needs to be robust and able to withstand scrutiny. And also it's very important that the trustees are comfortable on the price and the proposed payment method. Next decision to consider is whether we're selling 100% of the shares or a lower percentage. And we flagged already, it's just a controlling interest that's required. So the founder may choose to keep a minority stake. That's not uncommon in our experience. I think sometimes it can be seen as a form of reassurance to employees if the founder is not disappearing completely from the ownership model. On funding, well, there's a share price that's been agreed, but someone's got to pay for it. How's that funded? For most of the deals, again, we've advised on, it's usually been provided by the target company. There are some banks who are lending in this space. If you can point to a number of transactions now but I don't think that's the norm yet. There's also some specialist advisors or specialist funders who are active in the space, and both the banking and specialist funders routes should be explored. Obviously, the method of funding will have an impact on the timing of the payment of the purchase price. All the EOT models that we've been involved in have required the founders to be paid out over a period of time. And if I give you an example of the most common structure that we see to date, it's where an initial payment is made on completion, and that's funded from the company's cash reserves. And then there's deferred payments over a period of time. That's anywhere ranging between 2 to 5 years. And this is where the accounting advisor's input will be required. The deferred payment mechanism will need to be linked to the financial projections and in particular cash flow of the trading company. The deferred repayment schedule usually allows flexibility, as the founders don't want to impose payment terms that can't be met from the outset. And perhaps surprisingly, we haven't found a founder vendor yet who's wanted security to put in place for the deferred purchase price element. And again, that's quite a different approach to what we'd expect to see in an arm's length transaction. The next issue to arise is whether you have an individual or a corporate trustee. We saw in the previous diagram that it was a corporate trustee, a company limited by guarantee. In theory, the corporate trustee model should provide additional risk ring fencing against risk, although in practice it's just difficult to see where that risk actually arises. It also makes continuity easier, where you don't have to change the trustee every time an individual retires. There's no right or wrong decision here. Some clients like the idea of the corporate trustee because it gives an added formality to the role, because there's director positions involved. We've seen both models being used, and we're typically risk averse, so our preference is to use the corporate trustee model. Next is the timing of engagement with key employees or employees generally. Again, there's no set timetable here. Early engagement allows the benefits of employee ownership to be properly promoted and queries to be addressed. However, founders may quite legitimately prefer to wait until the tax clearance is obtained and all the legal documentation is put into an almost final form. This is I suppose, the piece where we defer to the EOT overarching advisors. And I'm not just saying that because Carol's moderating today's session. Our advice to clients is don't underestimate or undervalue the work required to engage with employees. That will range from setting up elections to explaining the benefits of employee ownership and dealing with all the queries which the employees raise. So this all needs to run in tandem with the legal documentation process, and there needs to be good lines of communication between the lawyers and the EOT advisors. Moving on to legal documents, there are 3 key commercial documents: the SPA, the trust deed, and the Articles of Association. The Articles of Association, I mean they are the articles for the trading company, but I suppose it could also refer to articles for the corporate trustee if that route is used. The SPA, well, it's going to be a much briefer document than would be used in an arm's length transaction. There'll be relatively few warranties. There may be indemnities in favour of the founder to deal with the position where the qualifying requirements for the CGT exemption are breached. But most of the focus in the SPA will be around the payment mechanism. I don't think there's any particular novelty from a legal perspective to the SPA. The trust deed, well, that's a more complex document, probably one that we're less familiar with. There's some good news though for the lawyers that are on the session. PLC has a style, which is a good starting point, although it's an English law document, so it's going to need to be kilted. And bear in mind that the PLC model document is all singing, all dancing, and probably needs trimmed down considerably. On the Articles of Association, again, we'll all be familiar with articles in our day-to-day work, but it's worth looking at the styles that are already out there. I'm not sure if the Employee Ownership Association have a style document, but there is a style that's been prepared by an English firm on behalf of the Department of Business, Innovation and Skills, as it was then known. And it's not a bad starting point for employee-owned companies. But again, it's going to need tailoring. I think it includes reference to employee councils, for example. The point to emphasize, I suppose, in relation to these documents is that the drafting process, again, will be more collaborative than typically we're all used to. Okay, so that's a very quick run through of the employee ownership and the more complicated governance structure and the suite of documents that are going to have to be put in place and then adhered to going forward. And I think that begs the question, is all that hassle worth it? Should we as lawyers be recommending that our clients consider the employee ownership route? Well, I'm pretty categorical here that the answer is a resounding yes. To start off with, we've got the tax advantages and a potential alternative solution to succession issues. The terms of the transition to employee ownership will be largely under the founder's control. So the founder can plan in advance as to when and how the transition happens. And that's a major advantage compared to other forms of exit. Employee ownership has a good track record. Various studies, and both Angela and Carol will no doubt be able to point us towards them, but these studies have concluded that employee-owned businesses achieve higher productivity and greater levels of innovation. They're more resilient to economic turbulence. They also have a more engaged, more fulfilled and less stressed workforce. And they've got a good record of succeeding, which obviously founders want to see where there's a deferred element of consideration. The model avoids some of the difficulties that come with other forms of exit. So you don't need to disclose confidential information to a potential trade buyer. It can be wholly self-funded, as we've looked at, but it can also involve bank or alternative finance provision to accelerate payment. It's a credible way for founders to recognise the contribution of employees to the success that's been made of the business. And it's a way to carry on the business's ethos. That ethos is more likely to continue intact under the EOT model. And I suppose last but not least, it hopefully can avoid some of the redundancies and perhaps closure of premises that can follow a third-party trade sale. So yes, I think is the answer. As legal advisors, we need to make sure that our clients are aware of the availability of the EOT model and the assistance and support which is available to explore it. But, and there is a but, we also need to recognise that it won't work for every business. So it's only one of a range of options that should be considered. But regarding the promotion of employee ownership, if you need more persuading than just my word about the benefits of the EOT model, well, even Wallace and Gromit like it. Wallace and Gromit were created by a Bristol-based company called Aardman, and they transitioned to employee ownership back in 2018. And that's a major company. They've got sales of 30 million, profits of about 2.5 million, 140 employees. Their two founders sold a 75% stake to an employee ownership trust. So thanks very much for bearing with me. We've had a chance to look at what is meant by employee ownership, the statutory requirements for EOTs. We've looked at the EOT governance model. I've shared with you our experience from a legal advisor perspective and talked about the key aspects of the transaction. And we've concluded by looking at why our clients should be considering employee ownership. So I'll pass back to Carol. That's the end of my presentation, and look forward to the Q&A session.
Again, many thanks, Bruce. We'll now move on to the Q&A, which Carol will manage as well as participate in. Over to you, Carol.
Okay, thank you. Before we do that, could we just ask a couple of questions on the about the experience people have got who are attending? Does everyone see the poll? Yeah. Okay, that's just about everybody voted. So, and there we've got the results. So most people attending haven't had experience directly of an employee ownership trust, and only 2 have experience of more than one of multiple transactions. And can I just also ask how you would rate your knowledge before coming onto this webinar of employee ownership trusts? Okay, thank you for doing that. And there we have the results of that one. So thank you very much for doing that. Bruce, before we actually go into the questions for the non-lawyers, and we've got some people from south of the border, can you explain what kilting means?
Oh, yeah, certainly. Yeah, so that's I suppose that's a term that Scottish lawyers use when we're turning a document that's governed by English law to be compliant with Scottish law. Yes, sorry, I should have explained that during the presentation.
Okay, thank you for doing that. So we've already got some questions in. And the first question, we'll click off the mark, and it was from George. George is saying that only 3% of the people that responded to the first poll were business owners, and he's saying, is that a bit worrying? We should maybe have explained at the beginning that this thread of webinars is really aimed at continuing professional development for advisors, so for lawyers and accountants. And that was in response to the Nuttall review back in 2012, where one of the key barriers to the adoption of employee ownership was the lack of knowledge and awareness in the advisor community. So CDS, with great vision, started this programme. Angela, would it be about 5 years ago?
Probably
6 years now.
Yeah. 6 years on, running every year a series of seminars. It used to be seminars face-to-face, now we're doing it by webinar, as well as doing helping law firms, accountancy firms, banks run with internal training sessions for their staff. And in fact, it has been really successful. Graham Nuttall himself comments on how much further ahead the Scottish advisor community is. But George, these webinars are open to everybody and everybody's welcome. But there's also different streams that run particularly for business owners. And I think there's one tomorrow, Angela.
Yep, yeah, we've got a series of what we call masterclasses, featuring some of our employee ownership expert advisors, as well as some live company case studies. So we've got one tomorrow featuring Stone Lighting, who's an employee-owned company, and we've got one in November time. But again, I'll do a quick plug for them at the end of the webinar.
Okay, right, let's go on to the questions for Bruce, and we've got one from Linda Barlow. And Linda would be interested in hearing if there are some common methods used to ensure that employees' ownership is more than just a financial ownership relationship through owning shares, i.e. do they get involved in appointing the trustees of the trust? How would you like to answer that, Bruce?
Yeah, so I think it would be very common for the employees to be involved in the process of appointing trustees to the employee ownership trust. So yeah, that is definitely something that we see across, I think, all of the transitions that we've advised on. I think I also referenced during my presentation that it would also be not uncommon for employees to have the power to appoint an employee representative to the board of the trading company as well. I think I flagged that it's not everybody's view that that's the best thing to do. I think I suggested that I think it conceptually it is quite a strong message to have an elected employee representative on the board of the trading company. Carol, I know that you perhaps differ from me on that view, and actually your input there is really helpful, because I suppose you have more ongoing day-to-day face time with the employee-owned companies and experience of how the boards are operating post the transition period.
I'm watching Angela's face here because I'm not sure how controversial I'm allowed to be. I think I agree. Conceptually, conceptually it makes sense. The company's owned by the employees, so it makes sense to allow the employees to elect someone to sit on the board at that strategic level in the company. I've been working in this field now for 20 years, and I haven't seen very many examples where it's been effective. I think it's a huge ask to take employees who are frontline shop floor workers and put them in a boardroom and expect them to be able to contribute confidently alongside people who effectively have other bosses who have years of experience, training, etc. I think it's a very, very difficult position, and there has been some really sad endings to that where people have ended up leaving the company because they've just been too stressed by it. So I think where the most powerful place to have employee voice is at the trustee level, which is actually the most powerful part of the company. The trustees effectively represent the major shareholding. So I think having the employee muscle at that point in the company where they actually hold the board to account can be much more effective, and just let the executive directors and external non-exec directors have responsibility for the company. And I think that's been particularly acute this year, which has been a very, very trying and challenging year for boards. I think it'd be very, very difficult for employees to sit with some of the very difficult decisions that have had to be made. But all companies are different. And I think the beauty of this, of the employee ownership model, is that you can shape it for exactly the circumstances of the company. So differing views, but I think it's finding what's right. And I'd be interested if you want to use the chat function for any feedback and follow up on that. Can we go on to a question from Andrew Sloan? Bruce, in your experience, how many employee ownership transitions fail to complete once they've formally started? What Andrew is saying is, due to the collaborative nature of the process, he's assuming it'd be a lot fewer than traditional sale routes, but he'd like to know what your thoughts are.
Yeah, I think that's he's quite correct there. I can't think of any of the deals that we've done that maybe I'm doing it. My memory is not 100% there, but I can't recall any of the transactions not proceeding once we've engaged with the process. And I think that, you know, the collaborative part of the process helps there, but also there's been a lot of work done beforehand before they end up at the law firm or the accountancy practice that's advising. Usually through the feasibility report or the options paper that are produced in advance. So yeah, no, I think the main difficulties are engaging the relevant individuals within the organisation to tackle some of the complex documents that need to be put in place. And I think we suggested it would take 3 months as a rule of thumb to perform that. That anticipates that there will be engagement away from the day-to-day pressures of the business for the founders and the key employees. So yes, as a matter of principle, I think it's quite right to say that these are much more likely to reach successful conclusion once the process has reached the stage of the professional advisors being instructed to commence the transition documents. Okay. Also, can I just point out, Carol, that there seems to be some sort of defamatory comment about poker skills in that message as well, which I'm going to let pass for now.
I didn't bring that up. Okay, quite a lot of questions when we're kind of getting close to the end of time. Angela, this one I think would be for you. Is there any support for companies and employees in terms of fees? And then I'll ask the next bit of Bruce.
Yeah, I mean, basically at the moment, what CDS can offer any kind of business owners looking to explore the options is an ownership succession review, which will review all their exit options. And should employee ownership deemed one of the viable options, we can certainly provide them with a free employee ownership feasibility study, which will again talk them through their options and what a potential EOT deal could look like for them. So that's currently what CDS can offer any interested parties looking to explore employee ownership further. Certainly there's a lot of other parties out there, kind of local councils and whatnot, where there's lots of support and funding out there that could be used for employee ownership transactions. But certainly from a Scottish Enterprise CDS perspective at the moment, we're coming in at the front end where it's the succession review and the feasibility study for employee ownership.
Okay. Thanks, Angela. And Claire's follow-up to that is, given all advisors that are involved in this, it could be high fees for this transaction. You got a comment on that, Bruce?
So I think you see from the governance structure model that it is sophisticated structuring that's required, but I suppose that they all tend to follow common path. So once the advisors have done one or two, then I suppose there is less new points that come to play in advising on the transaction, and I think the costs reflect that. So certainly I haven't seen a situation where the professional advisors' fees are so high that it prejudices the transaction completing. Not where Anderson Southern have been involved, but so yeah. But I think you've got to recognise that given the level of complexity, there is a need for professional advice. So there's a need for the lawyers. There's definitely a need for the accountants, and just as importantly, there's a need, I think, for the employee ownership experts such as ownership associates to guide the founder and the advisors to the path of successful transition. Thanks
for the plugs, Bruce. I think one of the advantages of the feasibility study is it does cover an indication of what the fees are likely to be, and that can lead to a conversation with the advisors if the fees do come in higher than what would normally be expected. So I think that's another advantage of taking advantage of the feasibility report. A question from Edward Bartlett. Regarding the taking of security, how do you see the taking of security over deferred consideration working in the context of maintaining compliance with the controlling interest requirement?
Yeah, so that's obviously a pretty important factor. I think it's clear that the trust can't give a charge over the shares that it owns in the trading company as security for the founder's deferred consideration element. I think it's possible for the company to provide security over its assets, but as I said during our presentation, the deals that we've been involved with, the founders have not insisted upon security being taken, and that was surprising to me for the first couple of transactions. But it's been a common theme through the ones that we've been involved in, and it's not due to the professional advisors not suggesting that route be properly considered or taken up, but it's not been something that's been done to date.
Is that because of the sellers' confidence in the future of the business?
Yeah, I think sellers have still got an emotional attachment, confidence, as you say. I mean, they know better than anybody as to what it takes for that business to succeed, and they'll have most of them will have a continuing role to a certain extent in the future of the business until such time as the deferred consideration is paid out. So I think against all that backdrop, they take the view that they're prepared to forgo the need for security protection.
Okay, and a question from Andrew Holloway of Johnson Carmichael. In terms of due diligence, you mentioned that it could be light touch. As a trustee, would you not want a more robust due diligence process undertaken to make sure that you aren't taking on something where there is potentially undiagnosed issue?
So that's a good point. If you take a step back, the trustees are effectively acquiring ownership, the controlling interest, paying a considerable sum of money. They need to be satisfied that the valuation is correct and that there are no potential material issues that's going to come out in the future that may deviate from that. But the reality is that those that are involved in the transition process are inextricably linked with the business. It's not a new business to them. They do know what's involved. So yes, I can see an argument that the trustees should be carrying a detailed due diligence process. But again, I can only share with you my experience, which is that's the extent of their current involvement in the business, their knowledge of the sector and the projections for the company's continuing success. Against that backdrop, it's been a light touch due diligence that's been employed, certainly from a legal perspective.
Okay, try and rush through just the remaining questions. You mentioned 25%, it's a question for Phil Jeffries of 2020. You mentioned 25% being a common amount of shares for employees to own. Do you see many businesses doing a second transaction to sell more shares to the EOT?
So I think the 25% reference is, that's it's not a statutory reference, that's a commonly used definition as to what would constitute an employee-owned business. So 25% of the shares being owned by the workforce. But when we're looking at the EOT model, well, actually it's a higher threshold. The EOT needs to have a controlling interest, so it needs to have at least more than 50%. Again, I think there are different views here. I do have some reservations around the hybrid model, where the employees also have personal direct interests, and I do wonder at times how there's a tension between that and the employee ownership trust, indirect ownership, and whether there's competing tensions there. So I think if employees are having significant stakes of up to 25% directly, then yeah, I can anticipate that there could be tensions in the future around that. So I think my preference is for the EOT to have a much higher percentage interest in the trading company.
I think that's a whole new webinar, isn't it? Have we seen any professional firms, in particular accountancy practices, transition to an employee-owned business?
I think I did see in the press an English law firm transferred to employee ownership, but I've not investigated the detailed terms of it. So yes, I think it has happened, but it's certainly not prevalent. I've not seen many of it. Certainly, I've not seen it in Scotland.
Yeah, I think I have explored it with a law firm in Scotland, and it was almost impossible because for the Law Society rules, it was difficult for the company to be owned by all employees and involve trainees, etc. So that was a difficulty. And just one last question, do the owners have to work until the full amount has been paid to them?
No. It's up to the owners what they want to do in terms of their future participating post the EOT taking control. A lot of them do. Most of them continue to be heavily involved, certainly at the front end of the transition period. But there's nothing to say that they couldn't just walk away once the deal's been signed.
Okay, thank you. I bet Angela's given me the look that we're run over time. Sorry about that. But thanks everyone for really good questions.
We've just got a short poll just before we close. Okay, hopefully you can all see the first question up there.
Okay, let's share results. So lack of awareness, again, the same as we had the last time.
And is there one more
Final
question?
This one's largely aimed at the advisors in the audience.
Hopefully that's increased.
That's encouraging. Let me just show the results. Okay, over to you, Angela.
We're very pleased to see that. Yeah, very pleased to see that. Again, just quickly before we close, I'd like to thank Bruce for his presentation today and for Carol for managing the session for us. I hope everybody found it useful. If any of your clients or indeed yourself are interested in exploring employership further, CD has been more than happy to talk you through the options. And really just wanted to remind you of our next webinar, which is taking place on the 18th of November. It's called Making Employee Ownership Work. Again, Carol's actually leading that session for us. Carol, I don't know if you've got anything you want to mention on it.
Very quickly, what I'm going to do then is I'm going to talk through the whole process from the initial conversation with the owners as to what their aspirations are, what they're trying to achieve. We'll look at how do you put a project team together. We'll look at different steps in the project, how we involve employees, what's the best way of communicating with employees, how do you maximise the benefits. And I'm also going to have a few companies that I've worked with coming to tell you from their point of view, and that would both be from the sellers and from the employee side as well. So I would hope most people would find that of interest, hearing it from the other side of the table.
And again, just in response to kind of George's query earlier, we're also running a series of masterclasses primarily aimed at business owners at the moment. The next one series takes place tomorrow at 10 AM. It's featuring stone lighting. We're also doing one in November on the 17th. And again, it's featuring Mac TV. So basically at the end of this webinar, a short evaluation will appear. Grateful if you could complete that. However, if not, we will also be sending out a follow-up email, which will include a recording of the session, a copy of Bruce's slides, all the answers to the Q&A, and notes of all our upcoming webinars or master classes. So thanks very much for attending today, and have a good day. That's it from me.
Okay. Thank you, everybody. Thanks, Bruce.
Thank you.